Thank you, Esther. What Esther didn't tell you was when we were figuring out who goes first, I said, well, what's the order of our panel going to be? And she said, well, we like to, at the Institute of Social Justice, save the best for last. So you're up first. Just as a brief remark, I'm always very honored to speak at the conference. It's a fantastic conference. I'm delighted and honored to be part of it. I'm also very thankful because what this conference does, it makes you think of things, or at least has made me think of things in a way that I never would have, right? And it makes me think about, when you think of trademark, as an advocate, we always think of, okay, what's the policy of trademark? And in trying to advocate our clients' positions, we always try to advocate the policy as best we can. But this forces us to it's forced me to look under the hood a little more and ask the question of, how does that policy affect social justice? And one would think, well, trademarks, what's the social justice there? But there's a lot of social justice in trademark. And so every year I look at the cases for the year and I try to think, how does this relate to social justice? And I'm going to start with the first case we talked about, and I'm going to confess this is a case we handled, but it's a case that I think really has a lot to do with social justice. It's a case that we handled for Under Armour, and the case involved a defendant, as you see here, called Armorina, and they made women's athleisure, kind of fancy, frilly women's athleisure products, and Under Armour sued for infringement of its Under Armour and Armour trademarks. Now, how does this relate to social justice? Well, when you have a case like this with a defendant who is smaller than the larger plaintiff, instinctivly people will play the bully card. And trademark bullying has been an issue that's been before Congress. A lot of people, it's on people's minds. It's something that reflexively a lot of defendants will raise. Well, that's a social justice issue, right? Are you using your trademark to bully me? Now, on the other side of that ledger is trademark rights. There's a duty to enforce trademarks. Now, why is there a duty to enforce a trademark? Duty to enforce trademarks because trademarks are very valuable to consumers, and the law recognizes that. They recognize that trademarks are economic shortcuts. It makes people's lives easier. When you see a trademark, it conveys a lot of information about a product, a service, and what you're getting in that bundle. And the law recognizes that that should be protected. Why? Because it helps people, and it helps people from deception. Deception and confusion are another important social justice issue. So this case actually, and there's very few cases that actually go to a jury in the trademark world or in the IP world generally, but in the trademark world, not a lot of cases go to trial. This one went to trial, and it was kind of interesting because a jury of 8 people got to decide where does things fall on this policy issue. And then all the while we got to educate and explain the jury, not just on trademarks, but why they exist and why they're important. And so I think it's helpful to kind of walk through how that case played out and how the jury ultimately decided. So our task in this case, again, because you've got, when you're in trademark cases, jurors are just ordinary people. Jurors, of course, are ordinary people in every case, but in a trademark case, they're going to have their own perception, and they're going to come to a gut decision on, oh, I think this is a problem, or I don't think this is a problem. And so it's very important to paint the right picture, to educate them, to persuade them, and at times, if possible, to entertain them. So in this case, the first issue is, and one of the issues the defendant raised was, you can't own a word. Armor is a word. That's not fair for you to own a word. That's bullying. You can't take that out of the English language. That would be unjust. It would be inequitable to do that. Our answer to that was to show the jurors and educate the jurors that Under Armour doesn't own just Under Armour as a trademark, but Armour, and that's a pillar of the brand. And we had to educate the jury on not only all the different marks that they may not personally have seen themselves. There are other Armour marks that Under Armour owns, like the Armour Bra, Armour Sight, Armour Vent, a full array of different Armour marks. So we had to educate the jury on that and show them that just because something is a word does not mean it can't be a trademark. Now, as trademark lawyers or IP lawyers, we all say, okay, of course, that stands to reason. But to a juror, again, they're not trademark lawyers. They think trademarks are patents or copyrights. They don't know the difference. So we had to educate them with examples like this, which we showed them, that some of the best known trademarks that they see day in and day out are ordinary dictionary words. And this doesn't mean, because Target gets protected, that that's being taken out of the dictionary. We also educated the jury on all the different Armour marks that Under Armour has used over the years. And we showed them, and I think visuals for jury trials are just so incredibly important. We showed them how the defendant's mark fits right in there. You can see that right there. We added that and how it fits within this family and naturally blends in with the whole family of Armour marks. Another argument the defendant made was that Under Armour is, this company that was created by a football player, and these are tough products for hardcore sports. We had to educate the jury that yes, but there's a lot more. And we had to show them that Under Armour has a lot of products that have style in them, and that function and style are just as important. And so we went through and found products that look just like the defendant's products and showed it to the jury to show that the worlds between these two companies is actually quite similar. Another thing that we did, and this is just incredibly important in all these cases, is we dug into social media. Social media is not just a landmine for kids to do stupid things. It's a landmine for companies to do stupid things. And so we really looked far and wide and got always, if you really look, you can get some great evidence. And one piece of evidence we had was this. These are endorsers for the defendant's products. Now, the defendant, again, was saying, oh, our products are frilly. They're kind of like athleisure. They're not hardcore. Well, these are two endorsers of the defendant, and this is their social media. And this seems pretty hardcore to me. And so actually, as I was closing to the jury, we played this, and this was just playing in the background. And it really does show the overlap between the products. Another thing we found similarly is many of the endorsers for the defendant have social media where they're wearing Under Armour. And the defendant, in fact, liked a couple of those. So thankfully, we had an associate on the team who knew social media much better than I and just found a trove of evidence. So, really, it's in these cases, especially trademark cases, looking under the hood, digging deeper is just so important. Another thing the defendant argued, which we see a lot in trademark cases, is that their logo distinguishes the product. They said, look, Under Armour's got its logo. Our logo doesn't look anything like Under Armour's. And so what we did to counter that was to show that Under Armour has a lot of collaborations with The Rock, with Lindsey Vonn. And those are the logos you see up top, but defendant's logo is in bottom middle. Steph Curry's logo, they have all these different logos. And so we argued, why would people not think that this is yet another Under Armour collaboration? And a lot of this is educating a jury that trademark infringement is broader than just source confusion. It could be association, sponsorship, things like that. The U is a big issue because the defendant doesn't have a U in their name. Under Armour does. And so what we did to show that is people spell Under Armour without the U all the time, including these two famous guys, Tom Brady and Vanilla Ice. I don't know, is Vanilla Ice famous still? I guess. But they were at Armour Day, which is Under Armour's a big event, and they spelled it #Armour Day without the U. And so pretty persuasive stuff to a jury. But the final thing that I think was so important was, again, going back to this thing about the equities of a big company and small company. And what we educated the jury on, and I think it's very important, was that Under Armour was David. Under Armour, you may think of Under Armour as Goliath, the big company, but it was David. It started in Kevin Plank's grandmother's basement. And this is a picture from his grandmother's basement. This is where the company started. And we pointed out that the phone number was 888-4-ARMOR. It was Armour alone. It wasn't always just Under Armour. But a lot of jurors will say in these trademark cases, what's the big deal? What's the harm? How are you going to be harmed? This company's doing it, like, you're not going to lose sales. And the answer is this. The answer is, why can't the defendant do what we did? And Under Armour understands, and brand owners understand, that things can start very small and get very big. And so you can't wait for the harm to happen. You can't wait for somebody to flood the marketplace and be in the same stores with a similar mark and a similar product. So at the end of the day, that argument did win the day, and the jury ruled for Under Armour, and Under Armour got an injunction and stopped it. But again, it was just all throughout the trial, and I emphasize this, was the social justice issues were so important. What's fair? Who can own this? Is this bullying? Why are we here? Why are we doing this? And it's important to explain to jurors, and fun to explain to them why trademarks are here, why they exist, and how they help us. So moving forward to another case this year, I'd be remiss. Oh, can we forward? think I've lost my forwarding. Perfect. I'd be remiss not to talk about NFTs. This is a very interesting case. This was a company called StockX, and this is still going on, but StockX makes NFTs, those and I'll oversimplify, digital pictures, right? And on the blockchain, basically. But you go to StockX and they have pictures of shoes, of sneakers, like the one you see here, and you see the Nike sneaker. And what they do is you buy that NFT, you buy that digital picture, and with it, you can do what you want. You can, oh, I think we've lost our slide there. Oh, okay. I'm sorry. That's just mine. Never mind. So you can take your NFT and you can keep it to have it and say, hey, I've got this great digital picture of a shoe. You could trade it or sell it, or you can give it to StockX and get that sneaker. So you could do those three things with it. And you can see on the right here is a little, they have a little thing on their website talking about the purpose of this, of the NFT and what they call the vault. And Nike wasn't very happy about this. And they sued and they said, look, this is something people are going to think. This is a product you're selling, which is our branding on it. It's got our product, it's got our brand, and NFTs are a thing. So you can't do this. This is not fair. It's not right. StockX had a couple defenses, or has a couple defenses, which are quite interesting. One is nominative fair use. They're saying, this is fair use. We are just showing a picture of a shoe that we are selling. And how is this different than Amazon using a picture of a product to sell the product? Right, so that's their first argument. The second argument they have is the first sale doctrine. And they said, these are virtual products, right? These are not a product. These are a claim ticket for a product, right? So you buy your NFT, then you claim your product. And so, again, this case is pending. We don't have a decision yet, but I raise it because it is a very interesting case on the, kind of on the cutting edge, right? Because you have these countervailing theories and policies. And one is, NFTs are now a product. This is a product that's being sold and traded. At the same time, it serves a dual purpose for identifying something as for sale that you can redeem it. So where the line is going to be drawn remains to be seen, but that is something to watch out for. Now, we did learn where the line was drawn on another case involving, now I always say Hermes just to annoy my wife. Figuring if I keep saying Hermes, she'll be like, I don't want that. That sounds horrible. So I'm going to keep going with Hermes, but it's Hermes. So I guess I should go with the real name. But so Hermes sells this Birkin bag, which is apparently a very popular bag and apparently a very, very expensive bag. And Rothschild is a digital artist, and he made these digital Birkin bags, and he used Meta Birkins as the name for them. And so he sold those online. He generated around $800,000 selling these on OpenSea, which is one of these large NFT trading platforms or marketplaces. And he claimed, for his defense, the First Amendment defense of Rogers versus Grimaldi. Now, Rogers versus Grimaldi is a very interesting trademark case out of the Second Circuit that involved actually rights of publicity. But under Rogers versus Grimaldi, something is not an infringement and is protected by the First Amendment if, one, it's artistically relevant, and two, the use is not explicitly misleading. It's a higher bar than confusingly similar for infringement. So it's got to be explicitly misleading if it's artistically relevant. So what did Rothschild say? He said, this is artistically relevant because I'm making a statement about these Birkin bags. He's saying that the having them furry comments on the fashion industry's animal cruelty and the movement to find leather alternatives. So that's his statement about these bags. And of course, Hermes is saying, well, these are just digital versions of our product, you're selling them. So on cross motions for summary judgment, this was in the Southern District of New York, they were denied. And the judge said, reasonable minds could disagree on whether these are genuine artistic expressions or whether this is just an intent to cash in on a uniquely valuable brand. And there was some statements by the defendant about how he was going to cash in on this, that the judge relied upon, at least in the motion to dismiss stage. And then on the issue of explicit misleadingness, the judge said this requires an application of the likelihood of confusion factors. It classically should go to a jury. What was very interesting is this case actually went to trial, and the jury found that this was an infringement. The jury had some questions to the judge, which kind of suggested that they were struggling with this whole whether this is artistic, does the First Amendment apply? And the judge, I think it was Judge Rakoff, right before it went to the jury, made some comment about how this is the type of case he thinks perfect for a jury, because he said, I don't know how this is going to come out. When the jury was deliberating, he goes, I have no idea how this is going to come out, which is again why it should go to a jury. But boy, oh boy, what a you could see the arguments going either way, but the jury found for Rothschild, and the trademark community is wildly speculating on how this is going to impact things, and so it's gotten a lot of press, a lot of attention, and yet another case that went to a jury, which for a trademark is quite unusual. All right, so now I will turn to the Federal Circuit and the Trademark Trial and Appeal Board. This is a very significant case involving a couple of Coca-Cola brands. It went to the Federal Circuit, and the question here is, can you enforce trademark rights for a mark that you have not used in the United States? Now, before this, we had a case called Belmora, which went to the Trademark Trial and Appeal Board, appealed to the Eastern District of Virginia, and then up to the U.S. Court of Appeals for the Fourth Circuit, where in that case, the Fourth Circuit said under Section 14.3 of the Lanham Act, which says you can petition to cancel a registration if it harms you. In that case, they said if you have rights to a trademark outside the United States, you can enforce them in the United States if you can show some sort of harm. So Coca-Cola went to the Federal Circuit, or went to the Trademark Trial and Appeal Board on this case, and what happened was the defendant registered Thumbs Up and Limca for soda, those two marks. Those are two very important brands for Coke in India. They own registrations for both of those in India. You can see the products right here. They petitioned to cancel Minaxi's registrations under 14.3, which was this Belmora case I was talking about. The Trademark Trial and Appeal Board sustained it, said, yes, you're injured. And Minaxi appealed to the Federal Circuit. Federal Circuit reversed. It's a very significant case because this really is one of those cutting edge issues. The Supreme Court will be hearing another case on extraterritoriality of trademark rights this term. But what the Federal Circuit said was Coke failed to show any damage. You have to show some sort of a damage in order to sustain this claim. They said they didn't show any lost sales. They didn't show any reputational injury. Now, Coke had said, well, there is an injury to our reputation because people are aware of our product. People who are people in the US who are from India or travel to India recognize these brands. And so that's going to hurt our reputation. And the court said, that's not enough. Just knowing your brand is not going to be enough. You have to show something more. Now, the court left it open on what you can show. And you can show, if you can show likelihood of confusion or actual confusion, maybe there's something there. So the door is still open there, but it's definitely something that remains to be seen. All right, I've got just a couple more minutes. Eric Brunetti, every year, he makes a show at our conference. So you can see him right here. He's the guy. Actually, he went to the Supreme Court. He tried to register FUCT, and there he was able to basically get the Lanham Act, part of the Lanham Act expunged as unconstitutional. So here he went a little step further. Instead of FUCT, he went full bore and went FUCK this year for phone, cases, jewelry, and bags. He said this is a critique of capitalism, of government, of religion, and pop culture. Bit of a stretch. If I had a phone case that said FUCK on it, I probably wouldn't think like, oh, this is a critique of capitalism, but okay, fair enough. Sure. I think you need something more, but okay. But the PTO refused it for a different reason. They said, this does not function as a mark, right? You look at that, you're going to say, aha, or, who's that weirdo with the phone? But you're not going to say that that's a trademark, right? Because it's a truly expressive message. And so the PTO, I think rightfully refused it and said, look, it expresses a well-recognized familiar sentiment, certainly in my house, yes, in my family. because I'm from New Jersey. And so the TTA, and he said, look, this is yet another abridgment of my First Amendment rights. You're abridging my speech. And the TTAB said, no. This doesn't require us to register a word that doesn't fundamentally function as a trademark. It's got to be a source identifier. Not this time. So, and that is, by the way, Eric Brunetti in front of the Supreme Court. This is him. I wouldn't use fake photographs. That is actually him. Last case. I mean, what better case to finalize here? Trump too small. The applicant sought to register Trump too small for T-shirts, and the PTO refused it because there's a section of the Lanham Act 2C that bars the registration of a mark that consists or comprises of a name, portrait, signature identifying a particular living individual, except by his written consent. So refused there, went to the Trademark Trial and Appeal Board. The TTAB agreed. They said, yeah, you can't register. They upheld the refusal. Then the applicant appealed to the Federal Circuit, and he argued, this is very interesting, that 2C is unconstitutional as applied to his case. And the Federal Circuit reversed. They said the government cannot discriminate against speech based upon its content, including commercial speech. And they went back to the Tam case, where the disparagement clause or prohibition of the Lanham Act was deemed unconstitutional. And the Brunetti case, our friend Brunetti, which struck down the immoral and scandalous prohibition in the Lanham Act. And the Federal Circuit said the government's interest in protecting the privacy of Donnie Trump does not outweigh Elsler's right in his expressing his political views. And as an official, Trump has a limited right of privacy. He has to show malice for defamation. So the court noted that political opinions are at the core of First Amendment expressions. And so as it applied to this case, Section 2C was unconstitutional. So I thank you for letting me talk fast. I thank you for your attention. I think I'm on time, Esther. Did I do okay? All right. And now